Okay, I'm going to call the next case, which is Jacqueline Davis versus BetMGM LLC. This is a calendar case, 20-minute argument on each side. Mr. Gonzato, do you have 20 minutes? You have 2 minutes of fire free that you can waive if you'd like. And if you want to reserve time for rebuttal, just ask that you keep track of it.
I'm Mark Gonzato on behalf of the plaintiff appellant. I want the court to know that I'm still operating under the effects of a medical procedure. I'm told if I speak slowly, I can be understood. I will concentrate on that. And with that, I waive any self-imposed limitation on questions. This is obviously a case involving the Lawful Internet Gaming Act in Michigan. LIGA is how I will describe it. And the court, in its order granting leave, has asked for responses to two questions. The first involved preemption under the Act. I'm sort of pleased to tell you that I have convinced someone of my position that the Court of Appeals erred in its application of preemption principles in this case, and I'm quite pleased to tell you that someone is the defendant. The defendant has not responded to my arguments with respect to preemption. I take that as a concession. I am required to talk briefly about why the defendant has conceded that point, because it is important to the other two issues that the defendant has reverted to in this case. The simple fact of preemption in this case is that LIGA does have an express preemption provision. It is Section 4(3) of the Act, and it provides that LIGA preempts any inconsistent law. Now, the Court of Appeals in an earlier case called Kraft determined that this was, in fact, the word law pertains not only to positive enactments, but also the common law. And perhaps the most important part of this case from the plaintiff's perspective is that the plaintiff in this case has asserted 3 common law claims. But the impact of the express preemption provision of 4(3) of the Act is that it basically eliminates any claim to an implied preemption. And the case that this court decided, which seems to me directly on point, and I think accounts for the defendant's lack of objection to this argument, is the Michigan gun owners case. Because in that case, this court held that where there is an express preemption provision in a statute, any attempt to imply preemption should be rejected, because obviously at the bottom, and this was sort of the point of my exegesis with respect to the various types of preemption in my brief, at bottom, preemption is in fact a question of legislative intent. And the legislative intent that's of course important to this case is 4(3) and its provision that inconsistent laws are in fact preempted by LIGA. But what the Court of Appeals did in the sort of muddled view of preemption analysis is it recognized 4(3) as a preemption provision. It recognized that LIGA does in fact preempt inconsistent laws, but it then proceeded to analyze the inconsistency by saying it's inconsistent because LIGA is a comprehensive piece of legislation. Well, the simple fact is the comprehensive piece of legislation that they were talking about is a piece of legislation that they already identified as not eliminating consistent laws, including consistent common law. So there is a fundamental error in the Court of Appeals decision in this case with respect to preemption, and for good reason. I think the defendant has abandoned that. So that you'll find nothing in the defendant's brief before this court about preemption. You'll find nothing about the question of whether Ms. Davis's claims are in fact inconsistent. They're not. And by the way, the amicus brief that's been filed by the Gaming Control Board is worth reading on that subject as well. So let me talk briefly then about the other issues that the defendant has resorted to now in this case, and that is that there is exclusive jurisdiction in the Gaming Control Board to decide this particular question. The default, if you will, on an exclusive jurisdiction claim is MCL 600.605, which is in fact the statute that describes the jurisdiction of a circuit court. And the law is quite clear. It is presumed that claims belong in the circuit court, where Ms. Davis, of course, brought this case, unless there is a clear legislative expression to vest exclusive jurisdiction in some other tribunal. And
Counsel, can you tell us what, whether it's preemption or jurisdiction, whatever we want to call it, what would be covered by the Gaming Act? What would be exclusively under the jurisdiction of the Gaming Act?
The most obvious, okay, are two Court of Appeals opinions that came out relatively soon after the original Gaming Act was passed by the populace of Michigan in 1996. Because there were two cases. Parisi was one, the second was McEntee. Okay, these are cases in which the plaintiffs lost money gambling under the Gaming Act, the original Gaming Act in Michigan, and they sued under, let us call them, antiquated statutes that were still on the books, which said that you could in fact sue to recover gambling losses. Okay, well, this is the most obvious, perhaps, example. And the Court of Appeals in both cases, I don't think there was much of a discussion worth having on them. You can't sue to recover money that you lost, despite the fact that it's provided in a Michigan statute. Okay, and there is another example. The Kraft case is an example where the plaintiff was saying the way the game operated, that was approved by the Gaming Control Board, was incorrect. And now that was another case where the Court of Appeals said that this was in fact inconsistent. I don't have any trouble with the decision that was rendered in Kraft. But the fact is, these are common law claims which have nothing to do with the Act itself. They are not in opposition to the Act.
What if the defendant has a defense that implicates LIGA? What if one of the defenses for the defendant is something that that is under their defense is asserting that this was something required under LIGA? So maybe the claims themselves aren't preempted or don't fall outside the jurisdiction. But what if one of the defenses or multiple defenses of the defendant does? What does that do to the analysis?
Well, it's an interesting question. It's not one that surfaced in this case, but I should think that, especially in light of the position that the Gaming Control Board, and I heartily recommend reading their amicus brief in this case, the position of the Gaming Control Board is we do not adjudicate these types of disputes. In my estimation then, to respond to your question, I think it's dependent on what the plaintiff is alleging, not what the defendant is talking about. Okay, and this is important to my way in terms of this exclusive jurisdiction. There are very limited circumstances in which the legislature has in fact vested administrative agencies with the ability to decide claims in derogation of the power of circuit courts. The Michigan Tax Tribunal is one example of that. But if you read the Michigan Tax Tribunal statute, it is explicit. It says exclusive jurisdiction to decide these things vests with the Michigan Tax Tribunal. The same is true with respect to the Workers' Compensation Bureau. There is an express provision with respect to exclusive jurisdiction. There is nothing in Liga or the rules that the Gaming Control Board has promulgated as a result of Liga, which has that type of express provision for exclusive jurisdiction. But remember, there is Section 4.3, and Section 4.3 is an express preemption provision. It means there are going to be cases under the very act that have to go to circuit court. So the defendant is ducking the question of preemption, but the same provision of the act absolutely destroys any suggestion that there is in fact exclusive jurisdiction. How can you have exclusive jurisdiction in an administrative agency when the statute that provides for that administrative agency says we don't touch any consistent laws? And remember, under Kraft, that word law in Section 4.3 includes the common law. So the defendant can't escape the problem created by 4.3 by switching their argument from preemption to exclusive jurisdiction. And there's one other aspect of this exclusive jurisdiction argument that I think needs to be stressed in this case, because the parties had a contract. Okay, and the contract is part of the record. It's called the Terms of Service. And there is a provision with respect to the law that is going to govern that contract. And in fact, rather ironically, in light of the position that the defendant is presently taking, there is a provision in that contract for exclusive jurisdiction. And that contract in Section 29 says that Ms. Davis irrevocably agreed to submit to the exclusive jurisdiction of the courts of Michigan for settlement of any disputes arising out of or concerning these agreements or their enforceability. So the defendant is before you switching to exclusive jurisdiction when it had a contract that did in fact address exclusive jurisdiction.
When you're done, I want to ask you a question.
I'm sorry.
When you're done with that point, I want to ask you a question, but you've been going on a roll, so I thought I'd ask. Can I ask?
I thought you raised your hand.
Okay, I did. I was trying to get your attention. Normally I would interrupt, but you were on such a roll.
It's your turn,
All right,
Justice.
can I ask you a question?
You can now ask.
Let me take you back
As long
a
as I
little
can
bit
hear.
in your argument. You said there are certain things you can't sue for, and one of them is gambling losses. Was that you can't sue for it because it's preempted?
Yes, it's preempted
Okay, so
under
let me
4.3.
just ask you a question. If that's the case, I think we pretty much agree there was a malfunction in this machine where it just kept producing winnings, all right? And so you're saying we've got a claim here, whether it's a breach of contract, but this is not that type of case where we're suing over losses. Let's just assume that the machine had a malfunction, and instead of taking 7% over the course of time of what the player puts into the machine, the malfunction is it's taking 100%. It's taking more than it should have. and the player discovers that. Would the player have a cause of action against the casino in that circumstance over losses?
Interesting question. I don't know if it comes up in this particular case, but if the money is considered converted under a common law theory, if that is the theory that's being offered, I do not think that 4.3 has any impact on that. Why is that? And that's because a cause of action like that, much like Ms. Davis's, okay, is not inconsistent with the purposes of LIGA. The purposes of LIGA is to set the what would you say, the general rules that are going to apply to, and mostly, just so you know, LIGA is mostly, as explained in the brief that's been filed by the Gaming Board, they're a licensing and monitoring of the gaming system. Okay, that's their job. Okay, but if you have a claim that is consistent with the purposes of LIGA, in other words, don't do this. Do not take money that doesn't belong to you. In this case, they froze Ms. Davis's account after winning, obviously. But again, we have an express preemption provision that only eliminates inconsistent claims. What would be inconsistent with the general purpose of LIGA if you can in fact sue a casino for converting your money? There's nothing inconsistent in that. And again, I refer you to the brief that's been filed by the Gaming Board. But the last thing that's been suggested by the defendant, and I did want to reserve a little bit of time, is an exclusive remedy theory. Okay, and this exclusive remedy theory is based on a mistake, a fundamental mistake in understanding Michigan law, because the exclusive remedy concept that the defendant is raising in their brief is based on this court's cases. I think most recently Stiegel is the case. It's based on the concept that where you have a new statutory remedy, that remedy is exclusive. Well, if you go back to Pompeii and the various cases that have stated that general rule, there's a qualification of that rule. And the qualification of that rule is something the defendant misses. And that is where you have a pre-existing common law claim, the common law and the new statutory claim operate together. That's basic Michigan law. And the fact is that their exclusive remedy is incorrect. The last thing I will say, the court has asked for a second question with respect to what it would look like if there was exclusive jurisdiction. I refer you to the brief filed by the Gaming Control Board, because they don't have the resources, they don't have the capabilities of litigating these types of claims. I'll refer you to that. But if there is a exclusive jurisdiction, I think this court's case, the decision in Stiegel and some various, that recent case and others, where the remedy has to be adequate. Okay, this court has reaffirmed Pompeii on that. The remedy would have to be adequate, and Ms. Davis has pled common law claims, and you would be putting in the hands of the Gaming Control Board common law claims. I will stop and try to resolve.
Excellent decision.
Thank you.
We want to hear what you have to say on rebuttal. We'll want to hear what you have to say on rebuttal.
Good morning, Your Honors. My name is Norman Akers. I appear on behalf of BetMGM. Our position and our argument are very simple. Our position is that the Michigan Gaming Control Board, the MGCB, has the exclusive authority to adjudicate Ms. Davis's complaints here. Every single appellate court in the state of Michigan which has looked at this issue over the last 20 years, has concluded, based upon the facts before it, that the MGCB in fact had exclusive jurisdiction. We believe that the court should reach the very same conclusion that every one of those courts has reached over the past 20 years. It is our position that the MGCB has exclusive jurisdiction over internet gaming platforms, including functions and malfunctions, and patron complaints relating to winnings and losings related thereto. The courts that have unanimously reached this conclusion over the past 20 years, and it includes cases like Kraft and Pappas, which are published decisions, have reached that conclusion on one or more of the following grounds, and there are some additional grounds. The first is the comprehensive and all-encompassing and pervasive nature of the statute and the regulations that have been promulgated pursuant thereto. I'll only cite a couple. MCL 432.304 paren 1 close paren says that internet gaming may only be conducted to the extent that it is conducted in accordance with this act. In turn, MCL 432.305, which creates the MGCB, says that it shall have not just the powers, but the duties to enforce that directive under the act. And under the rule which is promulgated pursuant thereto, R 432.641.7, the MGCB has the power to direct any corrective action that it deems to be appropriate in the circumstances. What happened in this case is very simple, Your Honors, and Ms. Davis had an appropriate remedy. She claimed that BetMGM was wrong when BetMGM voided the transaction on the basis that there was a malfunction in the equipment. That's a very critical provision for the following reasons. First, under Rule 432.645, without getting any MGCB approval whatsoever, BetMGM had the ability to void that wager based upon its determination that there was a malfunction. By the way, Ms. Davis's contract, which I also want to talk about, says the very same thing. Malfunctions in the equipment void the bets, period. Here was her remedy, which she had, and she exercised, and she lost. She had the right to go before the MGCB and argue this wasn't a malfunction. This isn't one of those situations which voids my quote-unquote winnings with respect to this case. She made that argument before the MGCB. By the way, she didn't do that until after she filed a Wayne County Circuit Court lawsuit and a motion to dismiss got filed, but she went ahead and she made that argument, and she didn't prevail with respect to that argument. That was her remedy. And there is no claim by Ms. Davis in any way, shape, or form that the decision that was made by the MGCB that there was a malfunction here was somehow wrong or improper. She would have had a limited right to judicial review, just like there are with respect to administrative agencies, if she had thought that the decision was wrong. But she didn't, in fact, even invoke that right because she concedes that the decision is a correct decision.
Counsel, could you explain more why you believe that is all an adequate remedy? Why is that enough?
It is an adequate remedy because the rules and her contract make abundantly clear that a malfunction will void all winnings. And therefore, her remedy is to go before the MGCB to determine whether in fact there was a malfunction. And she went before the MGCB, and the MGCB concluded that there was in fact a malfunction, that BetMGM's position that there was a malfunction was a correct position, and therefore there was no right to relief. That is absolutely an adequate remedy under the circumstances. And it is a little bit ironic that Mr. Granzato says, oh, well, this act is, it only prohibits you from invoking remedies which are inconsistent with the Act, it doesn't displace the pre-existing common law. Here's the problem with that argument, Your Honor. The problem with that argument is there is no right to collect internet or brick and mortar gambling debts in the absence of the statute to begin with. There are no common law remedies which are available. Now,
But isn't that true of anything that we make legal? Like, sure, there was no right to do online gambling or gambling without statutes. How does that mean that common law claims are suddenly, they don't exist, just because we've made something legal that didn't used to be legal?
because the common law says that you cannot collect internet gamblings. And what LIGA specifically says is internet gaming is only allowed to the extent that it is prescribed by and allowed by this Act. And what that means is that if you want to be able to collect your gaming winnings, you need to go according to LIGA's procedures. And those procedures set forth the exclusive jurisdiction which the MGCB has under the circumstances.
What are we supposed to do with the fact, or what do you make of the fact that the MGCB itself says we don't have jurisdiction? The very entity that you say is the keeper of all of this and the one who, I mean, are we supposed to assume that they have an incorrect understanding of their jurisdiction?
Yes, I would say several things in response to that, Your Honor. The first is that I would tell you is that this court has made abundantly clear, most recently in the Rovas case, that an agency's interpretation of what its powers and its duties are not dispositive on this court. The court will listen to it, but the court makes its own determination of what it is that the legislature intended. And that's exactly what Your Honors did in the Cameron case before the court. The Register of Deeds in Wayne County was acting up, wasn't doing things that it was supposed to have done under the statute, and the court said, go ahead and do it. That's number one. Number two, if one looks at the amicus submission which has been provided by the Michigan Gaming Control Board, the MGCB concedes that there is jurisdiction, it does so at page 5 of its amicus brief, there is jurisdiction to address these issues which arise under LIGA. There is a provision which says exactly that in the brief. The only dispute is whether there's exclusive jurisdiction, and we've explained to the court why it is that it ought to be exclusive jurisdiction under the circumstances.
You know, the gaming board did not find MGM to be without error here. They found some the failure to timely report the malfunction to be a problem, and then they just said they're not going to do any regulatory action in response to that. Why can't plaintiff pursue claims based upon that?
Well, the MGCB has the exclusive authority to determine what it's going to do with a licensee. And what the MGCB said with respect to BetMGM in this particular case, Your Honor, was you didn't make a mistake by claiming there was a malfunction when there wasn't. That would have allowed Ms. Davis to pursue a claim against that the MGCB would no doubt have allowed. And by the way, the MGCB allows these kinds of things all the time in the brick and mortar context. There's probably 150 people that are there who are enforcement personnel, despite the claim that's in the brief that there are resources which are lacked. And if dealers end up giving money to the wrong person, for example, those things get corrected on a regular basis. They get corrected all the time.
Counselor, what do you make of the fact that there's a rule in the brick and mortar context that addresses patron disputes, and there's no rule in the LIGA context that addresses patron disputes, suggesting that perhaps they don't belong in the gaming board in this context?
My response to that is that the MGCB has itself issued a publication which talks about authorized participant complaints. And it defines what an authorized participant complaint is. It is substantively identical to what a patron complaint is in the context of the brick and mortar statute. And there is a definition of authorized participant interest that is in LIGA. So it's clear that LIGA contemplates that the authorized participant is the same as the patron. There are other reasons why the courts have concluded that the jurisdiction of the MGCB is exclusive. Oh, by the way, one other thing, Justice Zara, I want to respond to this. This issue with respect to whether there are resources involved, of course, there's nothing in the record to say there aren't a sufficient number of resources. All they do is enforcement, and the MGCB's task was completed in this matter because there are no fraud claims, there are no conversion claims, there are no breach of contract claims which are out there. Those simply weren't permitted at the common law. And so they did their job. They looked to see whether there was a malfunction, and there was a malfunction. In this case, there was no error in BetMGM's conclusion that there was a malfunction here.
You'd admit, though, that the brief filed by the amicus brief filed by the board is not helpful to your position here.
I certainly would have preferred, Your Honor, if they had said, we have infinite resources to deal with respect to this issue. But as I said before, the fact that the brief indicates that they don't think that there's exclusive jurisdiction is not in any way dispositive on this court. The MGCB's activities were concluded when it determined that there was in fact a malfunction here. That's what its job is under LIGA.
I will say this, I have a little familiarity with Kraft and Pappas, even though it was a long time ago.
Because you wrote it.
And I actually found Judge Feeney's dissent to be rather persuasive. This is not at all like Kraft, and it's nothing like Pappas.
It is, I would suggest to the court, certainly Pappas is a different case because Pappas involved the issue involving a supplier. But it is like the Kraft case in the following respect. There are claims, there are common law claims which are being brought, fraud, because ostensibly there was something deceptive about the way that the machine would indicated what your probability was of winning. And Your Honor found that that was prohibited. This is like the Cousert case, where there were claims of fraud and negligence and spoliation of evidence that were arising out of this activity. This case is to say common law claims aren't preempted is to assume that there were common law claims to begin with. And by the way,
Well, let me just take a step back. You don't deny that when you sign up for this that they require you to enter into a contract.
yes, and not only do they require you to enter into a contract, Your Honor, but the MGCB has to approve that contract, which includes a provision in paragraph 30 which says if there are patron dispute complaints, you have to bring them to the MGCB. And by the way, with respect to every other claim, you have to arbitrate those claims.
Well, that could be an exhaustion argument, and they've exhausted. They went to the MGCB and they said, yeah, you know, there's something that was wrong here with this machine. They've exhausted what was available at the board.
And when
But you have a contract, and the contract does call for application of Michigan law.
the fact that it calls for application of Michigan law doesn't confer jurisdiction on the Michigan courts, and you have to read paragraph 28 in tandem, Your Honor, with paragraph 30, which says, with the exception of the patron disputes complaint, which are the authority of the MGCB, anything has to be submitted to arbitration. And paragraph 28 about the courts of Michigan is simply an acknowledgement that lots of times you have players that come from out of state, and you're subject to the Michigan courts no matter where you come from. This court knows very well that you can't confer jurisdiction by consent. And if one looks at what happened in this case, Your Honors, on March the 22nd, she starts betting on March 18. We're talking about a 5-day period of time. She starts betting on March 18. She puts in $50 of her own money. On March the 22nd, she receives some congratulatory note from somebody at BetMGM who's obviously just looked at who the winners were. But an investigation starts because it's unusual. And it's not surprising that an investigation would start because if one looks at the luck of the roulette game, if you go to the bottom right of it, on the right-hand side it shows you what you've bet. $50 is as much as you put in. In the middle, it shows what your winnings are. And then on the far left, it shows what your wallet is. Well, she's playing this game, which is why she played it for 3 days straight and why her last bet was at 3:55 in the morning on March the 23rd. There's a discrepancy, a huge discrepancy, between what's in the wallet and what's in the winnings. The malfunction which the MGCB found was multiplying in Malthusian proportions what it was she had supposedly won. The fact that she kept playing and didn't say anything about it was itself a violation of her contract with BetMGM, which requires her to notify in the event of any errors. She knew she didn't have the basis for a claim here. She knew that there was something that was wrong here. The real question that your honors need to decide is, are you going to allow for there to be fraud claims and other common law claims that are created in effect out of the air that could be inconsistent with what it is the MGCB is doing? So what happens, for example, if the MGCB says, I conclude there was a malfunction here, and some common law jury, or actually probably an arbitrator, because she was required to submit this case to arbitration, but here we are talking about it. What happens if an arbitrator reaches a different conclusion? Those kinds of differing standards are precisely why you ought to rule that in this case, her remedy, her exclusive remedy, is the remedy which is provided to her to go before the MGCB and have them determine whether or not there was a malfunction. Under the contract, under Rule 42.645, if there was a malfunction, she doesn't win. That's the end of the discussion. We don't even have to talk about resources. The MGCB has done everything that it was supposed to do with respect to this particular case. Another reason, Your Honors, why there is exclusive jurisdiction here is that the board possesses technical expertise over gaming in all of its facets. The board knows whether there's a malfunction with the extremely sophisticated software that's associated with this internet gaming. And it would be inappropriate for there to be an inconsistent determination made by an arbitrator or a jury someplace to the effect that, we changed, we don't care if the board concluded that there was a malfunction here. We think that there wasn't a malfunction and she should have gotten to her $3 million. That's exactly why there ought to be exclusive authority in connection with this particular dispute. I would indicate
Counsel, what, in your view, so it's anything to do with money and winnings, is that all exclusive jurisdiction?
I would say there's exclusive jurisdiction over the internet gaming platforms, including functions and malfunctions, and patron disputes about winnings and losses which are related thereto. That's what we think is the wheelhouse of LIGA and where the board has exclusive jurisdiction.
But what I'm struggling, there isn't, correct me if I'm wrong and I've missed it, but there isn't explicit language in LIGA that says what you just said, right? It says instead that there's a broad grant of jurisdiction for claims not inconsistent with
Right.
LIGA. So there is not an explicit grant of jurisdiction.
It is very true, Your Honor, that there is no exclusive jurisdiction provision using those words in quotations in the statute itself. But that hasn't been a bar to this court in the past, nor should it be, from concluding that there's exclusive jurisdiction when, as the cited portions of the statute and the rules that I gave to Your Honors indicate, the authority and the duty is comprehensive. In the case, a recent case where the court did that was the Demings versus Ecorse case, which is at 423 Mishap 49. The
So
court
say,
there.
if you could you repeat what you're saying is what you contend to be the jurisdiction
Yes.
that LIGA has, and tell me, is that what you're saying is the equivalent of claims not inconsistent with LIGA?
Those are the claims which relate to internet gaming platforms, including functions and malfunctions and patron complaints related thereto, are the essence of where there is exclusive jurisdiction. I'll give you, Your Honor, an example of something that's not, and this would be covered by the arbitration provision. Under paragraph, one of the paragraphs of the agreement, I think it's paragraph 12, there's an ability for Ms. Davis to participate in a chat room. And so you can jump into a chat room and you can talk with other winners and losers about what you think are good games and how you've been doing on a particular day. if there were a dispute, if BetMGM decided to kick her out of the chat room or wouldn't give her access, and there were a dispute with respect to that, that's not the kind of thing which would be covered by the exclusive jurisdiction that I'm talking about with respect to the MGCB, because that's not something which has to do with the essence of gaming. And those are the kinds of things which would not be covered and would therefore actually be covered by the arbitration clause of paragraph 30.
Counsel, one thing that I know LIGA requires is there's a rule that the platform is supposed to have some manner of protecting data in a secure manner, and that's actually approved by the board. What if there were a data breach? Would that exclusively come under the gaming board's jurisdiction?
That would probably exclusively come under the, obviously not the case before the court, but it probably would be part of the exclusive jurisdiction because maintaining that data is part of one of the express duties under the statute and under the rules.
Thank you. Mr. Gonzato?
I think Mr. Akers I thought he was doing the impossible. He spent his whole argument until prompted by Chief Justice's question without discussing 4(3), because there is no provision, much less a clear provision, for exclusive jurisdiction in the gaming board when in fact there's a provision which says nothing in this act touches consistent laws. And remember, laws include the common law. So we have 3 common law claims that are totally consistent with the purposes of LIGA. And we have a defendant arguing that there's exclusive jurisdiction. Remember, exclusive jurisdiction is exclusive. They have to decide all disputes, okay? And you can't make this argument seriously in light of 4(3). It can't be done. And I want to correct it, my limited time left. I want to correct what happened before the board, okay? Because the defendant has been, throughout these appellate proceedings, they've been of the view that she got a hearing before the board, and they just turned her down. They actually make this argument. That's not what happened. Okay, there were 3 letters, there were email and 2 letters, where the board made it explicit. We do not resolve disputes between casinos and players. We don't do that. That's not what we're for. She never got a hearing. In fact, she didn't even know about the disposition of the claim she made. It took a Freedom of Information Act on the part of her attorney to find out what the board did. Why? Because the board's only interest was in the entity that it oversees, the casino itself, and it found the casino violated a rule. It had nothing to do with Ms. Davis's claim. It had nothing to do with common law conversion fraud or breach of contract. The fact is, they signed off on these. So the bottom line is, if there is going to be, and again, I refer you to the Gaming Control Board's brief, okay, if there is going to be a determination that the Gaming Control Board has jurisdiction, exclusive or otherwise, over these claims, this court has to tell them, because they have not exercised that jurisdiction in this case. And Ms. Davis did not get any remedy before that particular agency.
Okay. Thank you, Mr. Gonzato. The case will be submitted.